again, a warm welcome to everyone here in the museum and watching us on live streaming on our website, copyright.com. We decided to call this program Copyright and Commerce. It's a neat little phrase that gathers up a lot of great discussion points, and I'm looking forward to trying to discover where the intersection between copyright law and business and Congress all meet. And I think it's a great place to do it here in Washington, and no better person to turn to first. She knew I was going to do that, to Marybeth Peters. Marybeth, welcome.
Thank you.
It's a pleasure to have you join us here. Your name was synonymous with copyright for a number of years, and before we get into the real serious discussion, I have to ask you a question. Are you enjoying retirement?
Mostly, yes. Some days I don't feel retired.
You're keeping busy then?
Yes.
Okay,
yes.
Great. Well, you know, everyone these days is fond of quoting the Constitution, so I thought we might start by doing that. Article 1, Section 8, Clause 8. Would you recite it for us?
I don't know if I recite it. I'll paraphrase it for you. This is the article in the Constitution that's very important to every copyright lawyer in the United States. It's the clause that basically gave to Congress the power to grant exclusive rights to authors for limited times. And it is to encourage science. It also says in the useful arts. Science is knowledge. Science is the part of the Constitution that relates to authors. Useful arts is the patent piece. So we have Congress at the center, basically in charge of putting in place copyright laws for the benefit of society, that's the knowledge part, and science for limited times. We can talk about limited times, but exclusive rights.
Well, you know, the phrase that I wanted to zero in on was that notion of the promotion of progress of science and the useful arts. Why would Congress, why would government want to be involved in promoting science and art?
Well, they certainly should be involved in promoting knowledge and also useful arts in a country that is just now being formed. And they learned from England about the importance of copyright, the first Copyright Act, 1710, in the United Kingdom, and we sort of copied that. But what the four founders of this country recognized that in order to have a great country, you really have to incentivize people who are talented, people who are creative. And the whole purpose of being creative, or in the patent system with the useful arts, is for the benefit of society. So it wasn't really, they looked at other systems. You know, the church used to basically, you know, commission pieces. They looked at how people earned their livings in the creative arts, and they decided that this is the way to go. Empower Congress for the benefit of the people of the United States.
For the public good. Well, given, let's fast forward to 2011, right?
Yeah.
And given the stress that Tracy Armstrong alluded to, that's, you know, copyright holders of all kinds feel today, is the government doing enough?
I am no longer with the government.
For the record.
Enacting laws is always extremely difficult. And I think if we focus on Congress and the power of Congress, and I'll recognize that the Copyright Office and the Patent and Trademark Office and other people in the United States government work very, very hard, day in, day out, looking out for authors and copyright owners. But for Congress, it's a very difficult task. Today, as Tracy mentioned, we have all kinds of new devices. We have all kinds of ways in which content is distributed, not just to people in the United States, but around the world. It doesn't have to be put in paper, and it can be sent out in perfect form instantaneously throughout the world. What's happened over the years is there were always authors, and then there were publishers. And then, of course, there was educational material, and there were libraries, and there were a variety of people who cared about copyright. But today, almost everybody cares about copyright. Certainly the consumer does. The consumer basically weighs in loud and clear with regard to certain copyright issues. So if you're a member of Congress today, I believe that members identify with authors, they identify with publishers, but they also identify with their constituents and with consumers, with electronics companies and technology companies. They have a lot of people who are in front of them trying to tell them what is the best way to move forward with the copyright law. So I think it's a harder task today, if you're a member of Congress, to basically get facts straight. And I don't know that in today, with all the issues that are before them, that they have the time that they used to have to consider things, you know, more leisurely. So, yeah, I think Congress probably could do a better job, and maybe the rogue website legislation will be introduced today, and that's a positive step. But I do think it's a hard job. But that's why the people who are here today, and that's certainly why I stay involved, because I really do believe that we do have to have laws that recognize the issues of today, and that getting the proper balance is critical.
One of the things that I think has changed copyright forever is just you were alluding to. It was a day before the digital era when copyright was pretty much the concern of, besides attorneys like John, it was the concern of authors and publishers and some film studios and recording labels. Today, everyone is a copyright holder.
Yes, and a user.
Right, and you're of two minds. At one point, you want to just make stuff and distribute it. On the other hand, if you've created a terrific new web video or something like that, you want to realize the potential of it.
That's absolutely true. But in the end, it's up to Congress and up to the people in this room to make sure that we get the copyright laws that we deserve. And I identify clearly with authors and those who take their rights through authors. I also, of course, care about a balanced policy. So one of the things I am doing in retirement is working on those issues.
Okay. Well, while you were in office, there were a number of reforms that took place.
Yes.
So now that you're not in office, I'm going to ask you, what are the ones you're proud of, and is there anything you might regret?
Let's start with proud.
Please start there.
Let's start with proud. Actually, I was with the Copyright Office for more than 45 years, but in my tenure as being head of the Copyright Office, there were so many challenges dealing with new technology, and I testified before Congress on many, many occasions, sometimes successfully. Sometimes they thanked me very much and thought I had great ideas, but didn't come to light, and sometimes they didn't agree, and that's part of what they do. I think if I look at what I'm proudest of, it's hard to pick out one. Not that the Act really works very well today, but it proved a concept. When the Digital Millennium Copyright Act went into play, because we had two new treaties that we really wanted to adhere to, and it became kind of a Christmas tree for a variety of digital objects.
This was in the late 90s.
This is 1997, 1998 when it finally passed. One of the things that, there were a few provisions put in for libraries, not rightly, but they got in there. But education was left out, and we really did work on getting something called the Teach Act. Now, the reality of the Teach Act is too complicated for anyone to use, so that's a very big negative. The positive side is Congress recognizing that they hadn't dealt with balance in the digital and online digital environment, and that they needed to, and they put in place a process. If you were doing it today, you probably would change the process. And I look out at Steve Tepp, and he was working on the Teach Act, and he got a call at 5 o'clock at night saying, we're sending over the members, and could you have somebody work with them on starting this process? And Steve volunteered and was there till about midnight. And that started a process. But I'm proud that Congress recognized it. I'm proud they looked to the Copyright Office to do it. I'm proud of the people who work in the Copyright Office and the litigation, not just legislation, but the litigation that we were involved with and basically helped make the courts understand what the issues are and come to decisions that I think better the policy and certainly serve authors and copyright owners well.
What about taking anything back?
Taking anything back, God. I don't know that I want to say I want to take anything back. It was what it is. You learn from it and you move on.
Well, the reason I'm asking is because we're going to talk about a variety of ways that Congress and the copyright holders have looked at reform over time. And I guess it's always a matter of an evolution, and where people try to catch up with technology, try to do the right thing, and then find out whether it's the right thing later.
Yeah.
That's tough.
That is tough. And what's interesting, when I look back, and John was much more involved in it than I was, when the 1978 law was put into place, people remember the gentlemanly discussions, the compromises that were reached. And if you go back and read all the legislative history, that's true. In the beginning, the parties came together, the Copyright Office was central, there were studies, there were discussions, there were compromises that were reached. And about 1965, you have a bill that's introduced that reflects where people are, and then you have the standout issues, almost all of which deal with technology. Photocopying, cable television, and those issues became bitter, were hard fought, and eventually the parties got together because Congress wanted to get moving, and they said to the parties, you either work out a solution or we'll work it out for you. That's a great incentive. But
it focuses the mind.
It focuses the mind. But it really shows that even in an era where people look back at people were gentlemanly and they spoke and there weren't all the interest involved, when it came to technology and some issues, it really was a very hard-fought battle. And the things that were put in place, cable, it's still around without too many adjustments, though we keep recommending adjustments, with library photocopying. That's not the technology of today. That's a part of the law that really does have to be updated. So the process is a hard one.
Right. Well, there's a case that no one could have envisioned in 65 or 78 or maybe even in 97, which your office took a strong position on and is still an open question today, and that was the Google Book settlement.
And you can laugh because I took a strong position.
Well, that's right. And I wonder if for people who might not be familiar, just if you could characterize what your position was and how do you feel now that Judge Chin has ruled in rejecting the proposal?
Okay, let's start with the Copyright Office is part of the Library of Congress. The Library of Congress was one of the places that Google went to digitize their books. And it was.
What did you say when they asked?
Well, they didn't ask me first. They didn't ask me first. And so what happened was there were people in the library who thought it was a good thing, and they said, well, maybe you should ask Marybeth in the Copyright Office. And Marybeth said, well, I think we have a little bit of a problem here. Google is relying on fair use. You're going to copy absolutely everything. It doesn't matter whether it's a brand new book or an old book, whether it's a work of entertainment, whether it's a research work. No, the Copyright Office recommends to the librarian that only public domain works should be part of the endeavor between the library and Google. And Google decided that that wasn't good enough and they walked away. But at that time I heard from a chief executive officer named Schmidt, who basically said to a group from the Copyright Office, you know, copyright should be an opt-out system. We get to use it unless you opt out. And as I saw this go forward, I said, I recognize this scenario.
What would that mean? Just to explain for people who might not be familiar. If copyright now is opt-in, why would it be opt-out?
It's Congress basically gives the right to authors. They are their rights, so they own them. And if you want those rights, you have to go to the copyright owner. That's the copyright system, if you need permission. There are plenty of exceptions. If, in fact, it flips and it's you get to use it unless the copyright owner objects to it, that's a very different system. That's the system that I strongly object to.
That's what you were calling copyright standing it on its head.
Yes, I did use that phrase.
Well, how do you feel now that Judge Chin has ruled? He said specifically that a lot of the issues involved in the case weren't for the courts, they were for Congress. So to take you back to that question.
He said that the orphan work issue, there is an issue with regard to books, which is less than it is with regard to other types of works, in finding the copyright owner in order to get permission. That piece is a small piece of the Google Book settlement. Congress almost enacted legislation. I thought it probably was fairly close. With regard to Google Books, Google got to use orphan works without searching for them. So it's that piece where the judge said that's for Congress. With regard to the other parts of it, he basically said, you went too far. You didn't just solve the problems that were at issue in the case, which was scanning, reproducing the works, and showing snippets. You created new business models for the future. That is too far. That's the part that I applaud in Judge Chin's decision, while recognizing that many, many good things were in that settlement, and we have to wait and see whether the parties will come up with a new settlement or what happens as we move forward.
And if I recall correctly, he also referred to the potential for an opt-in solution.
Yes, from the very beginning we said, of course, if you have a settlement and it doesn't bind you unless you opt in, then you are giving permission through that opt-in system. So of course, from the very beginning, I said it, as did others, opt-in was a solution. Google representatives repeatedly said that doesn't give us enough works to be in the base for it to be useful.
Well, finally, let me ask you, Marybeth, about the potential value. You spoke about copyright law and the Constitution as being, for the public good. Talk briefly about the value of book digitization from your perspective.
I strongly believe in the part of the Constitution that talks about the benefit of the people. I believe we are in a digital world. I believe that digitization is a good thing. I believe that it's good that libraries are digitizing their collection as long as they follow copyright laws. I do believe that some of the work is in the public domain. I do believe that some of the digitization may be covered by an exception. And I do believe that there's a big other piece that's there that requires licenses. And so therefore, all of that is part of the solution. It's not digitizing. You digitize, you follow the law.
All right, well, Marybeth Peters, thank you very much.